Hey, good morning, everybody. Welcome to Anderson University. I'm John Pistol, the president here, and it's an honor to welcome you and obviously the Indiana Supreme Court to our campus today. This is a special occasion. You may know that the Indiana Supreme Court hears cases a couple times a year outside of the court in Indianapolis. And so it's a real special honor for us to welcome Chief Justice Rush and the other justices, Steve David, Mark Massa, Jeffrey Slaughter, and Christopher Goff. Also glad to welcome the Madison County Bar Association and Attorney Kevin Eads, right down here in the middle, who is helping host this event, and then a luncheon afterwards for the court. So if you've been through security, you know the exits, hopefully, and everything. If there's any issues, there shouldn't be, but I want to welcome all the students from Indiana schools. If you are a student in a school, could you just raise your hand quietly, please? All right, very good. Well, welcome. We're glad you're here. So let me turn it over now to the court proceedings.
Thank you, President Pistol. We certainly appreciate it, and we'd love to give a round of applause to President Pistol as well as all of the Anderson University staff. You've been so welcoming to us, and I know the court is very excited to be here. We have a few thank yous and introductions that we'd like to make. My name is Catherine Dolan. I am the Public Information Officer for the Supreme Court. We would like all the members of the Madison County Bar Association to stand. We thank you for everything you've done to the president as well as local magistrate Kevin Eads. If you all could stand, thank you so much. As well as the local judges who are a part of the Bar Association. Senator Lannon and Representative Cook, thank you for being here. A good opportunity for students to consider possibly a career in government. We'd welcome you to that. The local public defenders, as well as deputy attorney generals and arguing attorneys. And we would like to welcome the CASA representatives who are here. We know we have a number of court-appointed special advocates who are joining us today. And if our own Supreme Court managers and staff could please stand. Thank you for being here. Now, this is an actual court proceeding, and so we want to remind you that you can't take pictures. So take out those cell phones and turn them on to silent, and I'm going to take one photo of this smiling audience, okay? So smile big, and we're going to put this on Twitter. Our Twitter handle is Twitter old? Is twitter.com/incourts. So look at the case at a glance that we've provided to you and consider asking a question after the argument. The court has what's called rules of conduct. They're not allowed to answer questions about the actual case at hand. So consider a question perhaps about their path to become a justice or something about government or the legal field in general. So we are ready to begin. I turn your attention to J.D. Bembry, who is a junior here at Anderson University. He is a member of the gospel choir. He's on the basketball team, originally from Fishers, and most importantly, a future lawyer, a business lawyer. He is our honorary bailiff, and he is soon going to gavel us into session, and then Chief Justice Loretta Rush will begin the proceedings.
All rise. Hear ye, hear ye, hear ye. The Supreme Court of Indiana is now in session. Please be seated.
Good morning. Welcome. Thank you, Bailiff Bembry. I want to welcome all the students and guests that we have here today. I'm Chief Justice Loretta Rush, Chief Justice of the State of Indiana. This is a rare occasion. We usually hold oral arguments down at the State House. We like to take them on the road so we can kind of bring the court to you, for you to see how the court works. If you ever want to watch a case, we have them all, and Dolan probably told you, we have all our oral arguments online. So this is our 43rd time since 1994 that we've gone outside the State House. So we're pleased to have many students here, and I'm going to announce the schools, and if you could all stand up when your school is announced, the teachers and students. We have Anderson Christian School, Anderson High School, Anderson High School Career Academy. You're here twice. Anderson Preparatory Academy. I thought you'd all stand a third time. All right. Anderson University. Burris Laboratory School. Daleville Junior Senior High School. The Excel Center of Anderson. Indiana Christian Academy. Inspire Academy, a school for inquiry. LaPel High School. There's some buses coming over from LaPel. Liberty Christian School. Muncie Central High School. And Muncie. Tri-Central Middle High School. Wapahani High School. Westdell High School. How about we all give a round of applause for all the teachers and students that came out. Quickly, before we get into the argument, I thought I'd give you a little background and have each of the justices on the Indiana Supreme Court introduce themselves. I was a former partner of a law firm and a juvenile court judge from Lafayette, Indiana. I graduated from Richmond High School, and I went to Purdue University and then the IU School of Law in Bloomington.
Good morning, Steve David. I am a graduate of Columbus North High School, the Bulldogs, down in southern Indiana, and ran 1 year of cross-country poorly for Columbus North. But I was on the speech and debate team with a gentleman named Mike Pence. So that's my only claim to fame there. I went to Murray State University in Murray, Kentucky, IU School of Law McKinney in Indianapolis. And in 1979, I was commissioned as Second Lieutenant United States Infantry, retired from the military after 28 years, been on the bench for the Supreme Court 8 years, and was a trial judge before that. And it's our honor to be here with you today.
Good morning. My name is Mark Massa, Associate Justice on the Supreme Court for 6.5 years. In 1979, when Justice David was being commissioned an officer in the United States Army, I was graduating from high school in my hometown of Milwaukee.
Thank you very much.
My hometown of Milwaukee, Wisconsin, and 39 years ago, this fall, I came to Indiana to attend IU Bloomington, and I've spent my career here as a proud naturalized Hoosier. I've spent most of my legal career as a state and federal prosecutor and was later counsel to Governor Daniels, and as I said, was appointed to the court in March of 2012, and delighted to be here in Anderson today.
Good morning, I'm Jeff Slaughter. I'm in my second year on the court. I was a 2016 appointee to our court by Governor Pence. I'm a native of Lake County, a graduate of Crown Point High School and IU's Maurer School of Law in Bloomington. And like my colleagues, I'm delighted to be with you this morning.
Good morning, I'm Chris Goff, and I joined the court a little over a year ago in 1979 when Justice David was joining the United States Army. I was 7 years old, and I enjoyed watching cartoons in Wabash, Indiana, where I spent most of my life. Until a year ago, I was the Superior Court Judge of Wabash County. I served in that capacity for 12 years. Before that, I was an attorney in private practice in Huntington, Indiana. I graduated from IU Maurer School of Law in Bloomington and Ball State University. I graduated high school from Southwood Junior Senior High School in Wabash. Glad to be here today. Thanks for your hospitality.
Thank you. And so before we start, President Pistol, thank you for having us here, and I thank all the students and the people who made this happen. So today, we're going to hear a criminal case. The appellant Marcus Sanders' counsel will argue first. And this is something we don't get to say very often on the Indiana Supreme Court. This is a criminal transfer case that's on a writ of certiorari, or a return from the United States Supreme Court. Representing counsel, and also to thank counsel today for traveling here and all the work that you did. For representing Marcus Sanders at counsel table, we have Leanna Wassman and Tony Walker. Welcome, Ms. Weissman and Mr. Walker. For the appellee, the state of Indiana, we have Steve Creason and Tyler Banks. And also with us today, we have Aaron Negengard, who is a former prosecutor for Dearborn County and now with the Attorney General's office. Welcome as well. Are the parties ready to proceed? All right.
Good morning. We would like to reserve 5 minutes for rebuttal, please. And Justice, as you already noted, we're in a unique situation. This case comes back to us on not just a remand from the United States Supreme Court, but a GVR. And in the GVR order, it's not just a remand, but the GVR order specifically states that they've considered the merits of our case and took action and sent it back to this court. And that's very telling to us because that means a few things in our opinion.
Counsel, I wonder if I might interrupt just for the benefit of the students here, if you might be able to just briefly summarize the facts of the case before getting into your argument.
Okay, and I'll try to do that as briefly as
quickly as
possible
possible,
because this is a long,
Understood.
extended case, and I've argued it once before you, and I'm back again. But briefly, the facts are that our client, Marcus Sanders, was accused of robbing 2 liquor stores in Indiana, and the state, without a warrant, procured documentation of his cell phone location data. And that became the big issue in the case, and we argue that they did that without exigent circumstances or without an excuse to the warrant requirement. We won on that argument at the Court of Appeals level. The state then petitioned to transfer, and we were reversed. And then we took a writ of certiorari up to the United States Supreme Court. We fully briefed that. The court vetted that case on the merits and remanded specifically for this court to determine on accord with right and justice and the Constitution and laws of the United States. So the U.S. Supreme Court has considered this case on the merits, and they've sent it back. And to us, that tells us a couple different things. It tells us that clearly Marcus Sanders' Fourth Amendment rights were violated, as in Carpenter, because the state is required to get a warrant to get that type of information. The third-party doctrine is not applicable. It tells us that. It tells us that they are concerned about whether or not the constitutional right to a fair trial.
There was no finding that the rights were violated. The remand was for the court to consider the facts of this case in light of the holding in Carpenter. Correct.
True, but they did consider the transcripts and they considered the arguments of counsel because that's clear in the GVR order. It's not just, a GVR order can be simply a remand in light of consideration of this case, but this remand order is more
you would agree
specific.
that, for example, exigent circumstances, that issue, whether or not they existed, are in play before us today?
That's a bit questionable in our mind because the United States Supreme Court did address the issue of exigent circumstances as far as Carpenter and at least acknowledge that that issue could be applicable in a case.
I don't understand that because in Carpenter it was 40 days afterwards.
Correct.
In this case, and I want to have you cite back to the record. The evidence in the record says that at 1:57 they sent the emergency writ to get the cell phone location data for Mr. Sanders, given the allegation that he had done some held a gun to individuals' heads. And it was not until several minutes later that Ohio apprehended him. Do you dispute that, and do you think that difference in that timing compared to the 40 days later in Carpenter, you think that by coming back and remand, the court is precluded from looking at that, the exigent circumstances?
Well, I don't necessarily say that the court is precluded. I think there's an implication maybe that the United States Supreme Court didn't believe exigent circumstances existed. But even if we're going to look at that, it's not really a fair and accurate reading of the record. And Justice David did a good job of parsing that in his dissent. But in order to get to exigent circumstances, we're going to have to show that the evidence was useful and necessary for law enforcement to find Sanders and take this perceived threat off the street. And they got historic records. So, to throw this back to you for an example, if I'm wanting to locate Chief Justice Rush today at this moment, I'm going to ping your phone. I'm not going to request where you were 30 days ago. So there was little merit or functionality in what they were requesting. It's more the mind run of,
But let's go to another exception with regard to the search warrants, because a lot of your arguments goes that if the fruit of the poisonous tree, if this was constitutionally impaired, this search, or the cell phone location data, then the subsequent search warrant that was signed by a judge that found the voluminous goods at his place would be thrown out, correct?
correct.
What about the good faith exception?
And you know what, that's interesting, but the state did not raise the good faith exception. But the good faith exception applies in situations where there's settled law in an area and an officer is following that settled law. And when the officer got the information here, the law was very unsettled. As this court well knows, when we argued this case 2 years ago, that the district courts were across the board on whether this was third-party doctrine or
Weren't
there
the
was a right
circuit
of
courts
privacy.
it was a fairly settled question of law until the Supreme Court reversed them. All but one of the circuit courts, I believe, had ruled the same way our court ultimately did they not?
I would somewhat disagree with that.
Okay.
I think there were more than one court, but it was also unsettled as far as the Seventh Circuit had taken that under advisement. But again, the state didn't raise good faith in this situation, and I don't think it's applicable, especially not applicable. We know good faith applies into the Indiana Constitution. Even if we could follow this through and say, well, there's a good faith exception under the Fourth Amendment.
Just so I'm clear, though, so in your mind, a split of authority among federal circuit courts of appeal would go to the good faith of a police officer executing a warrant?
Well, I think these are good police officers, and good police officers know that warrants are required. And if they want an exception and they want to rely on an exception, that's the exception to the rule. The rule is get a search warrant, as Justice David said in his dissent. The rule is get a search warrant. These are very good officers. They were very concerned about the threat that Xanders might have.
But didn't counsel advise the police officer that, excuse me, that the obtaining these data was not a search that implicated the Fourth Amendment, and therefore a warrant wasn't required? And they did their homework, didn't they? These officers who ultimately obtained these data.
Well, they did their homework, but now the state's now trying to rely on exigent circumstances, which really just doesn't fly, because the officers, the Indiana officers were good officers. They wanted to contact immediately their Ohio counterparts. So at about 11:30 in the morning on the Saturday after the robbery, they found the Facebook information, contacted the officers that they had a relationship with. There's a very tightly held relationship with the Renew officers and the Dearborn County officers. And the record's clear that immediately the officers that morning pulled up Xander's driving record from Ohio to find his address, and 4 to 5 Ohio officers immediately surrounded his residence and then waited for him to come out and followed him to the hospital where he was arrested. So what the state's now trying to say is, well, we needed this information to alleviate this threat. Where that doesn't make sense is they didn't ask for a ping. They weren't getting information that was useful to finding Xanders in that moment when this emergency was being carried out, and the Ohio officers already had eyes on him. So,
Well, in addition, just as it relates to the facts at the time that they sought the cell phone records, am I not correct that Indiana had already interviewed the defendant once, or had at least he was a suspect, or they were looking for him?
I think that's actually mistaken, Your Honor.
Okay.
I think they
But
had no idea.
They were looking for someone like him? What
They
was
were
exactly
looking
the
for
factual circumstance?
They were looking for someone that had maybe robbed the liquor store the week before, who was described as a black man with cornrows, which is not the description of our client.
But they
And
also,
very
they had a
little.
lot of information too before the interview on that with regard to they used his cell phone, used the number that called the liquor store to pull up his Facebook page. Now, we're not claiming any violation on that, right? He had a public
Oh, no.
Facebook page, and on his
That was
Facebook
good
page, he
officer
had
work.
the particular brand of alcohol, the Indiana liquor tax tag on I can't remember, the Patron alcohol. He liked Newport cigarettes, and a pile of money. So he had put up on his public Facebook page, and there's a lot of students here that like hearing about what people see on Facebook, different things that related back. You're not saying any of that was put in incorrectly,
That's
correct?
probably going to come back on retrial. What we're saying is he needs a new trial. And the problem is that this information that the United States Supreme Court was so concerned about that they granted our relief on our petitions for cert that we had issued from last fall, that the concern is that this gentleman wanted a jury trial. He didn't get a fair jury trial. The jury trial is so tainted. So it's an unfair situation to have this court then review the record, and you can't do that on a sufficiency, but to review the record and basically in a bench trial situation affirm a conviction on a
Counsel,
gentleman that wanted a jury.
where's the prejudice in this warrant if, let's assume for a moment, assume constitutional error by including the cell phone records in the warrant application. If the rest of the warrant application included the Facebook video, the information about the red Pontiac, and several other pieces of information, how do you show prejudice? What's your argument
Well,
on
the
that?
prejudice is that the United States Supreme Court has already decided they could not get that location data without a warrant. They got it without a
I
warrant.
Counsel, with
understand,
respect,
but
they
the
didn't say
warrant,
that.
the rest of the sufficiency of the warrant without it, that's my question. Let's assume
so-
that couldn't come in.
Well-
Wouldn't they still have been able to get this warrant on the rest of the information?
Wrong standard for what the court needs to do today. Because what the court needs to do today is be convinced, and there's actually two different strains of argument on this. It's a harmless beyond a reasonable doubt. And basically, it has to be according to the Koenig opinion that this court issued a few years ago, it has to be whether or not the state can meet it beyond a reasonable doubt that the illegal evidence contributed to the verdict. They said at the first trial that this was key evidence. They used it in opening. They brought in a triangulation expert to prove that this illegally obtained data showed Xander's, at least his phone, was in the location of these liquor stores. So now they're asking this court to pretend that had no impact on the jury and that he shouldn't get a new trial. That's the problem.
Was
He
that
should
during
get a new
lawyer's
trial.
argument, or was that based on evidence that the jury actually heard?
I'm sorry?
Was the key evidence point that you're talking about made during argument, or was it actually reflecting the evidence that came in during the
Both.
trial?
Both. I mean, they argued it in opening. They argued it in closing. They brought in a triangulation expert that testified for almost 100 pages of the transcript on how phone location data works and how that placed him in the locations, or at least his phone in the locations, and argued the fact that his phone showed he was in the locations of the robbery, so contrary to his defense that he wasn't there, he had to be there. That is so intertwined. The illegal evidence is so intertwined with illegally obtained evidence that the only alternative is for this court to grant a new trial. I'm going to point to...
And at that new trial, if your position prevails, the issue as to these other effects would be litigated at that new trial?
Wouldn't that be the
Or should we
appropriate-
remand with specific directions?
Well, the court can do one of two things. I mean, the appropriate place to argue some of this out might be at the trial court level, because the state's trying to place you in the position of reweighing what the Ohio magistrate understood and parsing out the evidence with the CSLI. They're wanting you to stand in the position of the trial court to see what was fruit of that poisonous tree, and then they're wanting you to stand in the position of the jury and basically do judicial
So it's
gymnastics.
acceptable to you if the evidence of the cell phone, how much of that contributed to the warrant or not, is an issue for the trial court on remand for a new trial?
It can be, and that's probably the appropriate place for it to be decided.
Would you agree that if this court remanded the case back, then they could get a warrant and get the same information today?
I think that's a question for the trial court, because I'd like to be able
Well,
to...
how would they be, what rule would you say they'd be precluded if they got a warrant now for the cell phone location data?
I think because they illegally obtained that could be potentially an argument of the fruit of the poisonous tree. But I think that's best litigated, again, at the trial court level. I think the problem here is Xander's asked for a jury trial, and in Horton, Justice, you wrote about how important the jury trial right is. The jury trial right, the implication of that is not just that you have a jury trial, but you have a fair, untainted jury trial. And that this jury trial was tainted. From the get-go, the state used what we now know to be illegally obtained evidence vis-a-vis Carpenter, wove it throughout the trial to the point that we can't extricate that from the legally obtained evidence. And so there's no choice but to grant a new trial in the situation. And we think that's what the United States Supreme Court intended when they not only GVR'd it, but they GVR'd it, making it clear that they had reviewed the merits of the case.
What if they did a warrantless search on 3 days of cell phone location data? What would your argument be today?
I still think it's a violation because
Anytime, even 2 hours of information.
It's information that we now know under Carpenter that Americans expect to be private.
So the author of Carpenter, which was Chief Justice John Roberts, said, well, we're only going to deal with the 7. They left a lot of openings in that. Exigent circumstances, the length of time. So you're not in agreement with those exceptions that he sort of carved out at the end?
I'm out of time.
Yeah.
May I answer the question?
Or you can answer now, you can answer on rebuttal, whichever you.
Okay, well, we'll leave that for rebuttal. Thank you, Your Honor.
Thank you. Mr. Creason.
Mr. Creason, if you would, ask that you assume for a minute that we agree that this case falls within Carpenter's scope, and further assume that we don't find there are sufficient exigencies, and we're left to determine whether or not we're dealing with harmless error. Ms. Wassman articulated a standard review with respect to harmless beyond a reasonable doubt in this context as being different than what would have been considered by a judge at the time he or she issued the warrant. That distinction seems problematic for the state. Can you speak and give me your best argument as to why this is not harmless beyond a reasonable doubt?
Certainly. May it please the court. First, the question about whether there is probable cause for the warrant is a separate inquiry from inquiry as to whether after the trial is conducted and viewing the evidence as a whole was evidence that was possibly admitted improperly, nonetheless what we call harmless error. And when there is constitutional error, that is a violation of constitutional law has occurred, which here, the Carpenter decision definitely says that the evidence here was improperly admitted unless
So you concede that. So you concede the first part, and you're saying that there's an exception, but you find under Carpenter that this search was unconstitutional,
well,
unless an exception applies.
all right. So the cell location data certainly falls under the ambit of Carpenter. The GPS data, which Ms. Wiseman misspoke when she stated to the court that the state did not request GPS ping data at the time from Sprint. That is incorrect, and that is at Exhibit 107 in the record. But be that as it may, so part of what the state requested certainly now would require a warrant. I don't think there's any question about that, but that is only part of the inquiry, and in fact isn't necessarily even the controlling part under Carpenter itself. If we want to talk about harmless error, the question is, if you take out that evidence, what evidence is left, and how did the trial unfold in such a way that can we be sure that beyond any reasonable doubt is the standard, that the jury would have still convicted him? And in this case, that is true. The state
how do we know that? How do we know that? Ms. Weissman quotes from the trial transcript that the state's argument during trial was that this was key evidence that was essential to the jury's the consideration of this case. Why?
Well, that was argument whenever they were arguing about whether the evidence was admissible. And that was before the trial was over, before we knew the defense's case, before we even knew all of the state's case in chief. And when you try a case, you don't know what witnesses are going to say.
Well,
you don't know what
on page
evidence.
602 and 603 of the transcript, it clearly said by the prosecutor, we would not have been able to get the warrant if we didn't have the cell phone location data. How is that not sort of game over for you?
Well, this court has never accepted the views of trial counsel at the time as controlling over the legal question when it can look at the whole record in the case. And in this case, what the prosecutor said is, on a Facebook hit alone, we wouldn't be able to get it. But they had much more than that, and so I respectfully disagree with the assessment of the trial prosecutor at that time.
So that doesn't constitute waiver as a matter of law, that assertion by the prosecutor?
No, it does not. This court has explained even a concession of constitutional error by the state is not binding on the state, and it's not binding on the court. Instead, the court will independently look at these questions to determine what is just. Let's look at, we're jumping back and forth between whether there's probable cause and whether there's harmless error. Here's the purpose, for the benefit of our audience. The idea of harmless error is that the primary purpose of a trial is a truth-seeking purpose. It's to determine whether a defendant is innocent or guilty. And not reversing on any possible error in a case if we reversed on any possible error in the case, that would undermine public confidence in the judiciary and in the criminal justice system. And instead, we only care about reversing when, well, I should say, it's not that we don't care, it's that we only reverse whenever there's an error that definitively made a difference in a case, that it made a trial unfair, because there's virtually inevitable presence of immaterial error in a case, as the U.S. Supreme Court has explained. So in that context, I'd like to run through the long litany of evidence, and I'll try to do that quickly. First of all, the CSLI that was used was only the cell sites. It was not triangulation. It was only the cell site, the sector of cell sites that the phone was on whenever they called Whitey's, the first liquor store that was robbed on the 31st of January, and 6 days later, on the 6th of February, the J&J liquor store. And that showed that his phone was in the vicinity of the scenes of the robberies. All the other evidence is independent of the CSLI. CSLI standing for cell site location information, or where your cell phone hits a tower. It is not GPS information. That is separate and different. So here's what the rest of the evidence showed that has nothing at all to do with the information that was received from Sprint, or is received in a different way, most specifically from a lawful search of his cell phone and the contents of his cell phone in his call records, which corroborate all but the location of where the phone was at the time. 18 minutes before the Whitey's robbery on the 31st, a red Pontiac G6 and a person resembling Xander's is on video, stops at a United Dairy Farmers gas station in the vicinity of Whitey's and asks for directions to the nearest liquor store. He's wearing similar clothes as the Whitey's robber, and most specifically the same type of shoes, which also the J&J robber and what they found at his residence. Then he placed a call, then his cell phone placed a call, we know this because of caller ID, placed a call to Whitey's 9 minutes before the robbery to find out when they would close. The person sold cash, Patron tequila, several packages of Newport cigarettes. All of those things were found either through his bragging on Facebook or in his presence or in his apartment. The Facebook posts then, they take the cell phone information and they plug it into the public search of Facebook, and they get a hit, one hit, Marcus Sanders. And they look at his profile page, and very conveniently, this is of course after it hit the second robbery, they find the photos and the videos of him showing the cash, piles of cash in large denominations, and the liquor, and bragging about what he does. 16 minutes before the J&J robbery, less than a week later, Xander's phone calls the store asking about its closing time. A red Pontiac G6 is driven. Cash, Cuervo 1800 tequila was stolen. The Facebook page shows that hours after this robbery, again, cash piles and the actual bottle of 1800 tequila. What's interesting about that bottle is that it's from the same lot that was delivered from Mexico. We have bills of lading that show delivered to J&J 6 bottles of that 1800 tequila. It's one of the large 1.5 liter bottle, or 1.75 liter bottles of liquor. They got that in September, I believe, of 2014, and by February of 2015, they hadn't sold a single bottle. But the lot number on there and the price sticker, which is unusual for a liquor store to use price stickers like this anymore, with the markings that the J&J price sticker give, on the precise point where the manager insists that all of her employees put the price sticker and the exact same price that they charge for this bottle of tequila is on his bottle of 1800, and there's only one missing, the one that he stole.
Counsel, tell us why, in your view, that the harmless error argument by the state isn't waived. It's certainly the case that the state could have raised harmless error in the Court of Appeals as an alternative ground on which to affirm the trial court's judgment. You could have done it, you didn't. The question, I guess, is should you have done it, and does the failure to have done so constitute waiver, and if not, why not?
We find regrettable that we did not raise harmless error in the Court of Appeals, but the focus there was on what we believed was a pretty conclusive case. The federal law said that this did not require a warrant because it was request from Sprint to give their records. It was not a Sprint of Xander's information or property in any way.
We thought so too, and we were both wrong.
I'm sorry?
We thought so too, and we were both wrong.
Well, that is true. Now we know that the court has changed its path on the understanding of that, and almost every other court in the nation was wrong about that too. But nonetheless,
and therefore, what follows from that?
Well, but at the time we're raising this, we're putting the best arguments forward to the Court of Appeals so they can decide the issue and move on, and that should have included harmless error, but it did not. But that being said, this court affirms in any basis on the record, and that includes its review of the evidence to determine whether, in fact, the error was material or not. Trial Rule 61 and Appellate Rule 66 also cautioned the court to not reverse
a similar
absent.
question to Justice Slaughter's. Did you raise the good faith exception, whether that applies now under Carpenter?
It's an open question as to whether the good faith exception would apply.
Can you make an argument for the good faith exception applying?
Certainly we could.
But you didn't?
It's an extension.
In the briefing, though?
No, we did not.
Okay.
We did not, because we believe that the court should decide the question on the narrowest grounds possible and on the most straightforward grounds so that this case comes to a conclusion as quickly as possible. That's a harmless error, and then it's also exigent circumstances. That being said, the rationale of the argument would be that courts were in wide agreement that the third-party doctrine applies to information held by not only courts but Congress and state legislatures agreed at that time. It was the consensus. And a bare majority of the Supreme Court has disagreed with that and reversed. And so under Davis versus United States, we should extend that holding to cover this scenario. The difference in Davis is that Davis involved when the United States Supreme Court in Arizona versus Gantt overruled Belton versus New York, which was a longstanding rule regarding whether you can search a car, the inside of a car when you arrest someone, and whether that sort of search incident to arrest applies there. Complicated, needless to say, the Supreme Court had decided Belton and said that was okay, and then reversed course 180 degrees. And so in Davis, 2 years later, maybe even a term later, the court decides that when officers relied on Belton, because we were the ones who switched gears here, and no one could have assumed that we would have, that controlling precedent allowed them to do it, so they were operating under controlling precedent. Here, this court had never decided that the third-party doctrine applied to cell phone records like this, and the U.S. Supreme Court had not decided. And so it would be an extension of Davis if the court were to go that path. That is a defensible argument, but there's a much easier argument to make. If I could continue on the litany of evidence, and I realize I'm trying to go fast, but there's a lot of it. I forgot to mention that Mr. Zanders, on the day of the Whiteys, at the same night, he walked across the path of someone sitting in a drive-through lane at a Gold Star Chili, walked right across the path looking like he had something in his pants and was having a hard time walking. And don't know what that is, but she had identified him at earlier stage in the proceeding and testified at trial about how she had seen this person walk across. Another independent evidence that puts him at the scene or nearby at the time of the crime. That's completely independent of the cell phone stuff. Then we have at 4:15, which is about 6 hours after the J&J robbery, we have him sending a text message to a friend, a picture of cash, along with a message that uses some offensive language, but this is at State's Exhibits 113 and 114. I prefer if the court were to read the text message itself rather than my using it here, but he suggests he doesn't need to pay income tax. He makes his own money. One way, of course, of making your own money is to steal other people's money. And then, of course, he posted on Facebook the video and pictures bragging. What's interesting about this is his bravado is increasing. Right? Every robbery, he's getting more and more brazen on Facebook. The search recovered handgun, the same brand and color of clothing that was used in the robberies, the 1800 tequila bottle that's put to the J&J, Newport cigarettes with an Indiana tax stamp, driving, he told police that he had never been to Indiana, he was arrested while driving his mother's red G6 Pontiac, the same ones that was used at the scenes of the others' crimes. And he admitted to his phone number, and his phone number was linked to the profile, and his phone number also had been evidence of the same pictures, the same type of pictures that were on his Facebook page. I'd like to talk a little bit about the exigent circumstances in order to clear up a few things. At the time in which he was arrested, where they found him, and the first time the Cincinnati police unit found him was minutes after, but it was after police in Lawrenceburg requested from Sprint subscriber information, details about the account, to make sure that, in fact, this number belongs to him. GPS information on that current ping, and if the GPS ping doesn't come back with anything, if your cell phone's off, or if it's a burner cell phone, or if it's broken, or the batteries ran out, you're not going to get a current GPS ping.
Is that disputed, Mr. Creason? I want to make sure, because that's something that I thought was very critical as to your exigency argument.
About what they requested?
Ms. Weissman say that the location of Mr. Zanders by the Ohio police came after the request for information from Sprint.
The request shows the request form itself and the fax form to Sprint that has the header that says that gives a timestamp that is, I believe, 1:56, and the officers in Cincinnati who would have not heard back yet anything at all at 1:59 is when they first saw the G6. He was not at the house. They did not have the house surrounded with him in it, or the apartments. He wasn't there. He was down the street. He was on his way to the apartment. And so that's another mistake by counsel. In her briefs, suggests that the state had him anyway, and they didn't need any information. That's not the case. At the time that the Dearborn County officers were looking for him, they didn't know where he was. And so if your GPS ping doesn't come back with anything, then you need to know something about where he lives, what he does, who he talks to, so you can go talk to them, so you can find out what places he might frequent. And that's why they requested on the form, if you want call data and you want cell site location data, you have to get 30 days worth. That's on the form. There's a box to check, and that's the way Sprint does it. They give you about 4 choices, and it's that or nothing, or it goes for review for their legal department. They didn't need a warrant at the time. Certainly no controlling precedent that they did need a warrant. And all the persuasive authority suggests, almost all of it suggested that they didn't need a warrant. They were acting very reasonable, and the Fourth Amendment turns on reasonableness. And in that context, the police don't know anything about where he is, but they do know that he's suspected in 4 robberies, at least 4 robberies, all of which were violent, all of which in which he threatened people's lives, and they all feared for their lives. And next time he goes and he robs someone at a liquor store or elsewhere, the chances are incredibly high, as we know from gun violence, that he dies, or a victim dies, or a police officer dies, or gets seriously injured.
You've got just moments left, but I want to talk about, there's 2 constitutions that were analyzed in the case from our court. One was the Indiana Constitution. How should we apply the Litchfield test, particularly with a degree of intrusion, given the holding in Carpenter? And if we take your argument the way it is, we usually have more protections under our Indiana Constitution than the federal. If we take your argument, this will be the only case I can think of where we have less protections under the Indiana Constitution than the federal.
My time is about ready to expire.
You can give me your Cliff Note version.
The Indiana Constitution, by definition, can't provide less protection than the U.S. Constitution. The Supremacy Clause in the United States Constitution provides that the United States Constitution is the supreme law of the land, and the state can't provide less protections. So this wouldn't be alone. It would be that Litchfield, the Litchfield analysis, Litchfield being the case in which the court really expanded on the Indiana Fourth Amendment, if you will. And so really we revert to a minimum understanding there. But the test is different. And this court's analysis of that, we believe, is correct. Again, there we deal with the reasonableness of police conduct. And at the time this was, and in the totality of the circumstances, there was no reason and no time to get a warrant.
All right. Thank you, Mr. Creason. All right, rebuttal. Mr. Walker, welcome.
Good morning, Your Honors. Good morning. I'd just like to clear up one misstatement regarding Exhibit 107, which relates to the request made to Sprint. The police officers had other options, Your Honor. They could have requested, we know they requested GPS data, they requested 30 days with cell site location information data, but they could have also, there's a space in there for other, where if they needed less intrusive information, they could have requested less intrusive information. So they are provided that option. The other point I'd like to make with regard to the CSLI data that they received is that that data only went up to 11 o'clock a.m. of that day. So that data would not have been helpful at the time they were actually sending the request at 1:57 in presently locating the whereabouts of Marcus Sanders, who in fact was in custody and under surveillance 2 minutes after that fax was sent.
So as to, and you're talking about the exigent circumstances or lack thereof, is that correct?
Correct. That's
so
not a help.
at the time they asked for the historical records, they had identified a suspect being the defendant.
Correct.
And they had identified or at least looking for a particular type of car.
Correct.
And they had identified where they thought the suspect lived, correct?
And in fact, officers were either en route there or already at his location, awaiting his arrival.
And so this information they obtained would have been looking over the shoulder the last 30 days.
Not only that, it would not have been helpful of finding him at 1:57 p.m. on that February 7th, because the data only went up to 11 a.m.
I thought Mr. Creason made a compelling argument for exigent circumstances if you accept the premise that if we don't know where the person is, we haven't apprehended them yet, then we don't need to get a warrant because we're in a hurry.
Well, here there's no ongoing emergency.
That seems to undermine the reason to get the warrant, which may only take 5 or 10 or 15 or 30 minutes. Help me understand that.
Well, there's no ongoing emergency here, Your Honor, first of all, because they have already identified him. He's back out of the state of Indiana in Ohio, so he's really not even an Indiana problem at this point. The Ohio law enforcement are already at his property at the time prior to when they sent in the faxed request in Indiana. We have to assume, we don't have a clear record, but there were communications going on between the Ohio officers and the Indiana officers. The other thing, I think, Your Honor, just taking a step back, if you look at Chief Justice Roberts' order in this case, as counsel pointed out, it not only says they reviewed the trial record, it says they reviewed the arguments in this case. So I think there is a possibility that they did consider exigent circumstances, because that was part of the argument that the state had made.
But the remand order from the Supreme Court didn't reverse our judgment. It simply vacated it in light of the Carpenter decision.
And I've had an education around this too, Justice Slaughter, as to what exactly granted, vacated, and remanded means, because there's several lines of thought as to what it means, and they do it different ways. There are alternatives in terms of how deeply into the merits the court goes when they do that.
And what's your line of thought about what that means here?
Well, we're hanging our position on what is explicitly stated in the order, and Chief Justice Roberts in the order says they reviewed the trial record and arguments in the case, which in a lot of the standard GVR language, they don't use that. But I think the other point here is the fact that still remains, Your Honors, that Marcus Zanders properly asserted his right to have a jury decide his fate on this case.
Mr. Walker, let me go back just a moment if I could. As to what options for information requests were available to police at the time this request was made of Sprint, could they have, instead of requesting 30 days historical data, requested information as to his current location at that time?
Correct, Your Honor. They could have pinged him at that time.
Just so I'm clear, are you or are you not arguing that we ought to revisit the state constitutional issue?
I think it has to be revisited, Justice Slaughter.
And what's the basis for that? I mean, we've got a federal court invoking federal law, sending it back to revisit our case in light of the new federal standard. Why does that imply we ought to revisit the state question as well?
Because the first order and analysis on this case, Your Honor, suggests that the police conduct specific to this case is okay. And I think that the GVR means that the police conduct was not okay, because they had the option to just deny our writ. But because that writ was accepted, I think is not only limited to the reasonable expectation of privacy, but it's also, I think, the high court saying the police conduct in this case was not okay. And as it relates to, Zanders having a fair and impartial jury trial as he requested, at this point, he still has yet to have an impartial jury trial, because the impartiality was destroyed by the admittance of the illegally obtained evidence. And there's nothing that this court right now can do to clean up or fix the unconstitutionality of the trial he had. So the only way for Mr. Zanders to really have a fair and impartial trial is to have the case remanded for a new trial. And in this particular case, he's in prison for 61 years. And he'll be looking in that rearview mirror all 61 years, and he'll never see a fair trial in his past. And I think that would be an injustice. And as it relates to any effort at this point to try to make the trial he had in July 2015 remediated in some way to look fair, it would just amount to placing lipstick on a pig.
Thank you, Mr. Walker.
Thank you.
Well, counsel, I want to thank you. What the audience got to observe today is what we have observed in the past, just excellent advocacy, excellent briefing. We really had some fantastic arguments and briefing today. So what we do next is we're going to have questions. Before that, we will take this case. We've all studied and talked about this case together. We sit around a table. We'll talk about this case tomorrow. We'll go around. We will first decide where's the majority, and then there'll be a decision with regard to the writing judge. Then the decision will go around to the other justices, and then it will be handed down, and it'll be in the books. So thank you very much. At this time, we have some time to take some questions. We always have some great questions from our students. You cannot ask about the case itself. You can ask about procedure, anything about the court. You can ask Justice David about his military days, being a prosecutor, being a private practitioner. Being the young. What's it like being the youngest one on the court? So anything's game. Do you have some questions? Good morning.
Thank you
We
so
got a
much.
question.
First of all, thank you so much for coming and taking the time to speak with us and just kind of allowing us to peek into your process. My question is really just kind of general. What were some of like the formative experiences throughout your life that kind of piqued your interest in the judicial system or in the law in general?
The question, if you couldn't hear, is that what were some of the formative experiences in our life that piqued our interest in justice and getting to where we are today? Justice Slaughter.
Well, I grew up in a family, my grandfather, my dad's dad was an attorney. He wanted his son, my father, to follow in his footsteps working for the family law firm. My dad spent a semester at law school, hated it, wanted nothing to do with it. But a generation skipped, and I, frankly, as a young boy, always knew I wanted to go to law school. I thoroughly enjoyed studying law and practicing law. Didn't know that I'd ever serve as a judge or have the opportunity to be a member of this court, but sometimes the stars align just right and things work out. But I enjoyed the practice of law. I've always, as a young boy, thought I wanted to do something like that, and have enjoyed my 2 years plus now having the opportunity to serve on our court.
Yeah, my experience is different. Before I went to law school, I'd never met a lawyer or met a judge. I hadn't really thought about law school and that. I moved 16 times growing up. I always liked to read. One of my favorite classes in college was constitutional law, so that's just what got me going, and then the opportunity came up.
I came to Indiana University to study journalism, and become a newspaper reporter, and I did that for the first 2 years of my career after college, and I covered some murder trials in the courts, and quickly realized that while it was important to chronicle what was going on there for my readers, I really wanted to be that guy on the other side of the bar trying that case. So that's what inspired me to pursue a legal education when I had the chance.
All right, we'll go with another question.
So what is it like to do your job on a daily basis? Like, what is your schedule like?
What is our job on a daily basis? What is our schedule like? Justice David.
Wow. Well, we have probably 5 different approaches to our daily job. Our core mission is to research and hear excellent oral arguments and then make a decision as to what we think the outcome of that particular case should be and why. What are the legal arguments? What's the precedent? What should our decision be? And then we'll work collectively. One of us will get assigned to write the opinion, and it may take 3 weeks or 3 months or 6 months, depending on the complexity of the case, how many issues, and where our respective positions are. In addition to having oral arguments, and we take about 80 to 100 cases a year, and the default is to have an oral argument such as this, normally at the State House. We're looking at anywhere between 15 and 20 cases every week where someone wants us to take the case. We have to take death penalty cases. We have to take life without parole cases. We have to take any case in which any judge in Indiana has declared any part of any Indiana law unconstitutional. That's required. Otherwise, our authority is discretionary. So that essentially means we have some guidelines, but the bottom line is what 3 of the 5 of us are interested in taking on what we call a petition to transfer. So we spend a great amount of our time reviewing those cases individually, then collectively in deciding what to do. Our days start at different times and they end at different times. We have a number of extracurricular obligations, initiatives that we're all involved in, supporting our trial judges, helping our prosecutors, our public defenders, educating. So we have a lot of different things going on. So my typical day is I try to get in the office early so I can sometimes get out and beat the downtown Indianapolis traffic since I live out of town. But it's a very challenging, and every day is different. And we get to spend some of our time working with our colleagues in the General Assembly and our colleagues in the executive branch. So it's a wonderful, wonderful position to have.
All right, next question.
How do you prevent your personal beliefs from affecting a case?
How do you prevent your personal beliefs from affecting a case? Justice Goff.
Yeah, so one of the first things you learn in law school is that your personal beliefs have to be set aside, and you must make your decision based on the law and apply that law to the facts as they are found in the case. So that's really core to the mission of lawyers. That's really core to our American system of justice. And so it's just what lawyers and judges do. Sometimes it's difficult. We're human beings, but it's necessary, and it's what lawyers and judges do every day.
Another question.
If you could give an estimate, how long can a court case get up to?
How long can a court case take? Justice Massey, you want to talk about that, or?
Question is, how long does a typical case take? You know, it just varies, I suppose, on the complexity. And I think you heard from the record today that the crime occurred, I think, in 2015. So that case worked its way through the trial court, then to the Indiana Court of Appeals, then to us, then it went to the Supreme Court of the United States, and then back to us. I would say that's highly unusual. So I think our Court of Appeals turns cases around, I think generally in between 90 and 100 days, and we certainly, I think, issue an opinion in virtually every case that we take during the course of a year. So it's just really hard to say. Some of them take months. Some of them can take several years.
We had in Indiana last year, we had 1.3 million cases filed. We have our excellent Madison County judges. Here, some cases may be on a quick, with regard to need quick relief, like a protective order in a couple of days. So sometimes it could be hours before something comes before a judge, and sometimes days, months. And if it's particularly complex and it comes up to our court, it may be a year or so.
What makes a case stand out to you guys as to why you want to review it in front of the public?
That's a great question. What makes a can stay out? When we decide we're going to exercise our discretion on taking a case, what are the factors that we look at? Justice Slaughter, you want to go with that?
Sure. We have probably 800 to 900 petitions each year asking that we grant discretionary review in a case that's been decided by our Court of Appeals. And we decide our grant rate, if you will, the last year and frankly in several years has been under 8%. So it's only a small percentage of the cases in which we're being asked to hear a case do we actually decide it. And the kinds of considerations we look at are, one, is it an important legal issue that's not just deciding the particular dispute between these parties, but is it a matter that's likely to have statewide significance to all kinds of cases? Is there a conflict in the lower courts about how a particular issue of Indiana law, or in some cases federal constitutional law, is being interpreted, being understood, being applied by the lower courts? Those are the principal considerations. Far less common, but occasionally we'll come across a case in which jurisprudentially it probably makes no sense to take it. It really is not going to add to our body of case law at all, but one of us is persuaded and persuades the rest of us to conclude, this really shouldn't stand. Even though it's jurisprudentially insignificant, it's really important to these parties, and whether it's a civil or a criminal case, a wrong is being done, an injustice is being done, and only we can correct it. And we'll take a case under those circumstances, though that's really very narrow, seldom happens. Overwhelming majority of the cases we hear are because they have important legal questions that need to be decided statewide.
And I'd just add, we have about 600 judicial officers in Indiana, about 400 trial court judges who do a really good job. I mean, we get to read their orders and rulings, so sometimes there's not an error. We also have people file themselves without an attorney. We're different from the U.S. Supreme Court. We look at every single petition or petition to transfer that comes before us, even if it's handwritten and somebody being in DOC. So you've got 5 sets of eyes looking at that. And I remember an early case that I wrote was a handwritten petition, didn't have an attorney, that you read through, you found the issue, and you thought, there's something here, and we took the case and wrote and righted a wrong in that. Next question.
Thank you. I would like to begin by thanking the court for providing us this transparent experience to see how our justice system works. And thank you to our security staff for keeping us safe here. Thank you. My name is Nuad Melki. I'm a sophomore, student of political science and national security. I'd like to ask, our Constitution, one of the most fundamental parts of it is granting its citizens habeas corpus. I would like to ask the court, do you think habeas corpus is just a right granted from the Constitution, or is it an inherent liberty? Thank you.
Justice Massa.
Wow.
He was a federal and a state prosecutor.
I think this is really a question of natural law, and I think raises the issue of how do you look at organic and natural law? How do you view the founding of this nation? How do you view the work of the founders in Philadelphia and what they believed about natural law and the inherent freedom of man? And I think that is all wrapped up in the idea of habeas corpus, that if you are being held unlawfully, that there is a place you can go for relief, and a judge can issue that famous writ to have you released. So, at least in my view, that goes to the idea of fundamental law, that we are endowed by our Creator with certain inalienable rights, and that government exists to protect those rights, that government doesn't grant us those rights, that we have those from our Creator. That's certainly my belief. I don't think it's universal among the judiciary or among the political classes, but that's my answer to your question that I was not prepared to have posed today. Thank you.
Great question and a fantastic answer from Justice Massa. I concur, and I would only add that I wear this wristband that says the rule of law always, because it's not about us, it's about the rule of law, our U.S. Constitution, our Indiana Constitution, and no matter what you do, from my perspective, America is special because we have this rule of law, and that makes us, in my opinion, the envy of most of the world and the enemy of some, because we have this fundamental understanding, this fundamental natural law discussion. I think our founding fathers may not have worn this wristband because they were uncertain as to how this would all play out, and so the habeas was a sort of a stopgap fail-safe that you can always challenge. I think the good news is, as a practical matter, rarely needed because the system is a good system the vast majority of the time, and due process does exist everywhere, but there is still an opportunity to challenge that. And I think that's an example of intentionally put in, but hopefully now frequently not usually needed. So that, I think, reflects very well on our system and the people, all of us, that support our rule of law.
And let me just jump in with briefly, if I may, recognize the constitutional habeas corpus privilege that exists in the original document is based on the common law writ of England, the Great Writ. Let him who holds the body explain why he's being detained. In other words, bring criminal charges against this defendant, or let him go. That's very different from the codified writ of habeas corpus that Congress has enacted, that is commonly litigated throughout the courts today by the Attorney General's office very capably on behalf of the state. We hear cases in state court that will become the subject of a federal habeas corpus petition down the road. But the statutory right that often is invoked today is a post-judgment, post-conviction right that's invoked. If somebody's already been not only detained, but charged, convicted, sentenced, and the judgment then is being challenged on federal review, when we see them, or when they come from our courts, they're under 2254. Federal habeas petitions are 2255 under the federal code. But the issue in those cases is, does the state conviction violate a federal constitutional right, which is very different from the constitutional right of habeas corpus and the common law right that I suspect you may be studying in legal history. So just understand the difference between those two doctrines. Same term, but they often have very different meanings and applications in practice.
Thank you. Next question.
Thank you all for being here. I know it's probably really difficult for you guys to be away from family. And speaking of family, how difficult is it for all of you guys to be away from your family and not really see them probably as much as you can?
Yeah, great question. You know, how does it affect your family? Is it hard to be away from your family while you travel? And Justice Goff, good question for you.
Well, it's a good question for me today, and thank you. My oldest daughter is in labor right now, and so if I could just be the first. Cigars for everybody. I want to welcome, a little prematurely, Adela McCowan into the world, because she should be born today.
Tell them about your father-in-law.
So the chief has asked me to talk about my father-in-law, and my father-in-law is a naturalized citizen from Mexico. And I shared with the chief and folks that interviewed me for this job that until he was 18, he didn't own a pair of shoes. He cut apart a piece of rubber and tied them to his feet. And so, you know, when I was explaining to him that I was going to apply for this job, it wasn't something that he really he understood or registered. He was very happy for me. He said he'd pray for me, but that's been difficult. It's been a transition to get some of my family members to really understand and appreciate the significance of what we do. But what a wonderful problem to have the chance to consider cases of this importance and of this gravity, and to come here and help you folks understand a little bit about our system of justice. I think we all sacrifice in what we do. All of these folks here are, excuse me for saying, they're rock stars in their profession. The folks that are sitting in the front row have given and sacrificed much for our profession. And we all sacrifice when we choose this, but I think we all do it because we believe it's worthwhile. And I'd encourage any young person here today to consider the law, because it really is a very meaningful way to serve your fellow human beings.
Could you share with them the story of who your oldest daughter's husband and your relation to him?
So the chief asked me, sorry, sometimes I'm a little slow on the take, but so I come from Wabash County, and Wabash County, I always share, is so small that there's only 2 judges, and our kids married each other. So my daughter married the other judge's son, and that's why I had to leave town.
This question is for Chief Justice Rush. I would like to know what it's like for you as a woman being a Chief Justice in the Supreme Court of the state of Indiana.
Yeah, her question was what it's like being a woman as a Chief Justice. Well, I'm proud that Indiana was one of a couple of states in the country that didn't have a woman on the court. And we noticed. I mean, when I graduated from law school in when I went to law school in 1980, if somebody said, "Did you want to be a judge?" there were no. I mean, there hadn't been a judge on the U.S. Supreme Court. I think Sarah Barker was on the federal court. So now little girls can look at it. In fact, a little girl who was in 4th grade sent me her mom, and I don't know her. So her mom sent me a picture. She dressed up as the Chief Justice of Indiana for History Day this year. So that's a moment. So I think it's important that not just in gender, but I think it's very important that our bench represents our citizenship so that people come to the court, that they feel that we have a broad base of diversity. So very proud, and very proud of the team that I work with up here as well. Thank you for the question.
Thank you.
What is it that you guys find most interesting about your job?
What do we find most interesting about our job? Justice Bassett, Justice David, anybody want to?
My 4 colleagues. It's just an incredible privilege to serve with them and to sit down around our table every Thursday. What we did here this morning, we typically do every Thursday morning at the State House. In fact, tomorrow we'll have 2 arguments. We usually have 3, but we put one of them today for the road show. But Thursday's the best day of the week because we take the bench at 9 a.m. and we have 3 arguments like the one you just observed, and then we go into our conference room and spend the rest of the day deciding the 3 cases we just heard, and then deciding those 15 to 20 other cases that Justice David referenced a moment ago, and whether or not we ought to take them and set them for argument. And the job demands a fair amount of humility. You can't be right all the time, and you realize the wisdom of your four colleagues when they talk you out of your position, and that's just a privilege, and I think by far the most interesting thing about the job.
Thank you. Next question.
Again, I want to thank you for coming here and letting us witness this case. It's very intriguing to watch. I come from the Anderson Career Center along with APA. My name is Lillian Balasone, and my question is, what was the biggest obstacle you faced in getting the privilege to be where you are today?
What is the biggest obstacle we faced in getting on the court?
We don't have enough time for me to list mine. I think I'm the poster child for, it's not a matter of how many failures you have, it's the fact that you keep trying. So I'm first generation college student, first generation lawyer. Every one of us have had obstacles, or you want to call them opportunities. It's really how you look at that, and have had successes, but have had far more failures, some small, some larger. I can talk about my personal failures, but I think the question, the answer is you can't let those deter you. When I, for example, expressed my interest to my friends about the possibility of applying to the Indiana Supreme Court, the first couple of people said, "There's no way you'll get selected." So, it's a matter of living your dreams and perseverance. But you're going to have bad days in school and bad days on the court, but it's a question of getting up the next day and going after it again. That helps.
Thank you.
My question is, what inspired you to be a judge?
What inspired you? Her question was, what inspired you to be a judge? I had been a practitioner for 15 years, so I had spent 15 years in courtrooms bringing cases, and really loved it. I mean, I just love the fact that you take issues and you apply the law to facts, and every day you get to learn new areas of law or facts, depending, and then watching the job of the judge with regard to parsing through and listening to both sides and finding it. I thought it was intriguing. So in 1998, a group came and asked me if I would consider running for judge, and I thought, as Justice David, I can't see myself as a judge, but it's a fantastic job. It's a demanding, but it's a fantastic job because you're always looking forward. How can you settle this dispute? Because a lot of people, when they come to court, something bad's happened, and they need to get it resolved. They need to get it resolved fairly, and they need to trust the process. So,
how many years of college did it take to get this job?
Anybody?
Typically, you go to college for 4 years, get a bachelor's degree, and then law school is typically a 3-year program. And so beyond that, there's usually not formal education, but you pick up a lot of practical experience. Most judges practice the law for a number of years before they have the opportunity to take the bench, and you learn a lot through the practice of law. So while that's not formal schooling, it is a lot of learning.
And Justice Massey, you went to night school, correct? Because you were working full-time, and Justice Slaughter's got a master's degree, correct, on top, so you had additional school. So slightly different varieties, but generally you have to have an undergraduate degree. And then to be a judge in Indiana, or to be a justice on the court, you had to either served as a judge for 5 years or been an attorney for 10.
Thank you.
Hello. I am from Muncie Central High School. When I was little, I watched my mother and grandmother, who are both lawyers, practice in their offices, because that's where I was practically raised. And I have seen many differences in between how they feel about things or how they feel that the law should be practiced. So I was wondering, especially Justice Goff, you are my father's age, and Justice David, you are 10 years younger than
I'm
my
your grandfather's age.
Yeah. So
I see where this is going.
So I'm very curious to know as to how the differences in maybe like the way that you were raised and your age differences affect how you interact.
Well, even though I may die earlier, you go ahead.
Let me just say, we have completely different pop culture references around the table when we quote movies and such. Justice Goff has a whole different set of films to draw on than the rest of us.
And he uses emojis better more than we do, I would say, as well.
Well, what a great question, and how lucky you are. If you get a chance, have a conversation with that lady behind you today, because I think she and her daughter had a similar life experience that probably informed both of their careers. I made fun of Justice David a little bit at the beginning of the day because he made it safe for me to do that. And I can tell you that having people like Justice David, who are a little bit older than me, serve in this capacity and go before me, I think made it safe for me to have an ambition, to leave the door open that maybe I would have an important voice to lend to this process. And so what I always try to do is I try to listen. If somebody is a little bit older than me and they've got some advice, I want to hear it. Please give it to me. And then I try to, if I offer something, make it worth their while, make it worth their listening to. But I think that it's important to approach that with humility. I think it's important to understand that the law is big and people experience it very differently. So your take on it is going to be very different than mom's or grandma's, and you're going to have something important to offer. So keep having those conversations, and I promise you I will too.
Thank you.
I would only add from my aging perspective, nobody has all the answers, neither the young people or the older people. And if you have a chance, Google, YouTube, take a course, generational bias, understanding the different generations, what was significant historically in the respective generations. It'll give you an amazing opportunity to look into the perspectives of people younger than you and older than you that will help you understand where they're coming from, help with your communication with them, and really make you an all-around better person no matter how old you are.
And he's not that old either. He's done 3 Ironmans just since I've been on the court.
Yeah.
So
And I think he's young because he's only a year older than me.
She reminds me of that.
Our senior Justice David.
Thank you.
We have one last question.
Thank you. So I'm an exchange student from India, and I had not heard about the word attorney. So can you tell, what is the difference between an attorney and a lawyer?
Justice Slaughter, you want to?
Well, attorneys don't necessarily serve as lawyers. I mean, there's a term in the law known as an attorney in fact, who simply is responsible for overseeing the responsibilities for a person, for a matter. Attorneys at law or counselors at law are those who advise clients who are admitted to practice before the bar of a court, as the lawyers before us here did today. But usually in common parlance, an attorney and a lawyer are used synonymously.
Thank you.
Thank you.
Thank you.
Thank you all very much. We're ready to. Thank you for the questions.
All rise.